Section 153C of the Income Tax Act, 1961, is, a special provision. It allows the Income Tax Department to assess the income of a person who was not the primary subject of a search operation under Section 132. This happens if books of account, other documents or assets belonging to this other person are found during the search. The primary aim here is to bring any undisclosed income of this other person to tax. This section actually ensures that tax evasion, even if indirectly discovered, can be addressed effectively by the authorities. It extends the reach of a search beyond the searched premises and persons, aiming to capture income that might have otherwise escaped assessment. For Section 153C to be invoked, there must be a direct link between the material found and the other person. The material must genuinely belong to them. It's not enough for the material to just mention the other person or contain some reference. The assessing officer or AO of the person searched must first be satisfied that such items indeed belong to the other person. This initial satisfaction is a crucial checkpoint in the entire process. Without this properly recorded satisfaction, the jurisdiction to proceed against the other person under Section 153C cannot be validly assumed by their respective assessing officer. This step is fundamental to the legality of subsequent actions. The term incriminating material is central to these proceedings under Section 153C. This refers to documents or assets that, on their face, suggest the existence of undisclosed income. It could also pertain to transactions that have not been offered to tax by the other person. Essentially, it means something that clearly reveals or strongly indicates tax evasion. Simple business correspondence, publicly available information, or general documents would typically not qualify as incriminating. The material must have a direct and discernible bearing on the computation of the total income of the other person for the relevant assessment years. This requirement ensures that the provision is not used for initiating fishing or roving inquiries into a taxpayer's affairs without a solid basis. Before the assessing officer of the other person can issue a notice to commence assessment or reassessment, the assessing officer of the searched person must record a clear satisfaction note. This note is a formal document. It must explicitly state that the seized books of account, documents, or assets belong to the other person. Furthermore, it must also clearly articulate that the material has a bearing on the determination of the total income of that other person for specific assessment years. This satisfaction note is not a mere procedural formality, it is a jurisdictional requirement. The absence of a properly recorded and well-reasoned satisfaction note can render the entire proceedings under Section 153C invalid and void from the outset. The case of PANCH TATVA Promotors Private Limited versus the Income Tax Department brought some really critical aspects of Section 153C into sharp focus for taxpayers and tax professionals alike. In this particular instance, a search and seizure operation under Section 132 was conducted on a third party, an entity entirely separate from PANCH TATVA. During this unrelated search, a pen drive was seized by the tax authorities. Subsequently, the department officials formed a belief that this pen drive contained information relevant to PANCH TATVA. This belief set the stage for initiating proceedings under Section 153C, a move that the company then challenged legally. The Income Tax Department's primary contention was that the data stored on the seized pen drive was incriminating in nature. They alleged that this data pointed towards undisclosed income that rightfully pertained to PANCH TATVA. Based on this premise, the assessing officer recorded the necessary satisfaction. Following this, the jurisdiction over the matter, along with the pen drive, was transferred to PANCH TATVA's assessing officer. This officer then sought to reopen assessments for several previous years, relying heavily on the contents of this single pen drive as the foundational incriminating material. PANCH TATVA's central argument was that the mere discovery of a pen drive was insufficient to trigger Section 153C. They strongly contended that the pen drive itself was not inherently incriminating. The nature of its actual contents needed to be rigorously established through proper examination. The company argued that the department had not followed the due process and jurisdictional requirements before initiating assessment proceedings against them. The core legal question that the courts had to adjudicate revolved around whether a pen drive could automatically be considered incriminating material. Furthermore, the case questioned if its discovery alone, without detailed examination of its contents and a clearly recorded satisfaction note, justified the reopening of past assessments. The case highlighted the need for the tax department to demonstrate a clear link between the pen drive data and any potential undisclosed income of PANCH TATVA, rather than making broad, unsubstantiated assumptions. The judgment delivered in the PANCH TATVA Promotors Private Limited case strongly reiterated an important and fundamental principle of tax law. A pen drive, a USB flash stick, an external hard drive or any similar electronic storage device is, by its very nature, only a container or a medium for storing data. It is not in itself an incriminating document or asset in the context of tax assessments. The actual information, files, documents, or records stored within the pen drive must be thoroughly examined to determine their character and relevance. Only if the actual data itself is found to be incriminating can proceedings under Section 153C be lawfully and validly initiated against the other person. This distinction is crucial for protecting taxpayers from overreach. For the contents of a pen drive to be legitimately considered incriminating, they must clearly and directly suggest some form of tax evasion by the taxpayer. This means the data should point unequivocally to income that has not been disclosed to the tax authorities in the regular returns filed. Alternatively, it might indicate assets that have been acquired from such undisclosed income. For example, if the pen drive contained a parallel set of accounting books showing substantial unrecorded cash sales or unexplained cash credits, that would likely be considered incriminating material. However, if the pen drive merely contained publicly available company brochures, general business correspondence, or personal photographs, it would not meet this stringent threshold regardless of who it belonged to. The assessing officer cannot simply assume that because a pen drive belonging to, or even just mentioning, a particular taxpayer is found during a search, it must necessarily contain incriminating material relevant to that taxpayer. There is a positive and non-negotiable duty on the assessing officer to meticulously examine the contents of such an electronic device. After examination, the assessing officer must apply their mind judiciously to ascertain if any specific information found on the device has any real bearing on the computation of the income of the taxpayer for the relevant assessment years. This application of mind must be clearly documented and evident from the official records of the case, particularly in the satisfaction note. The PANCH TATVA ruling decisively underscores that the burden of proof lies squarely with the Income Tax Department. They must effectively demonstrate that the material seized, which in this specific case was the data contained on the pen drive, is indeed incriminating in nature. Furthermore, they must also show that this incriminating data specifically pertains to the particular assessment years for which notices under Section 153C are being issued. The judgment serves as a significant check against the arbitrary or casual use of seized electronic devices to initiate wide-ranging tax reviews without specific, credible, and documented evidence of undisclosed income for the identified periods. The Income Tax Act lays down a clear, sequential, and mandatory step-by-step procedure that the assessing officer must scrupulously follow before issuing a notice under Section 153C first. During a search operation conducted on Person A, if any books of account, other documents or assets are found which the assessing officer believes belong to Person B, then the assessing officer of Person A must record a formal satisfaction. This satisfaction note is a critical document. It must clearly state that the seized items belong to Person B and that they appear to be incriminating for Person B, potentially affecting Person B's income assessment for certain years. Once this initial satisfaction is properly recorded, these documents or assets are then formally transmitted to the assessing officer who holds jurisdiction over Person B. Upon receiving this material, the assessing officer of Person B must independently examine the received documents. Crucially, this assessing officer must also record their own satisfaction. This second satisfaction note must confirm that the material would indeed impact the determination of Person B's total income for specific assessment years within the applicable period. A notice under Section 153C is appropriate in certain defined situations. For instance, imagine a pen drive is lawfully seized during a search conducted on Company X. This pen drive contains a detailed spreadsheet listing cash payments made to Mr. Y for consultancy services during assessment year 2019-20. Upon verification, Mr. Y had not declared this income in his tax return. If the assessing officer records proper satisfaction outlining these facts, then a notice to Mr. Y would likely be considered valid. Conversely, a notice is not justified and can be quashed if the prescribed procedure is flawed or if the material is not genuinely incriminating. Suppose a pen drive is found during a search of Company Z containing publicly available annual reports of Company P or general market analysis reports mentioning Company P. Even if the assessing officer receives this pen drive, they cannot validly issue a notice based on such material. This is because publicly available reports are not incriminating material suggesting undisclosed income. The PANCH TATVA judgment reinforces this vital principle. It ensures tax assessments are based on concrete evidence, not on mere suspicion or irrelevant findings, thereby protecting taxpayers from undue harassment and fishing expeditions.